We have enough members under our rules so we can start our debate. And hopefully, when we get 9 people here, we will have at least enough to hold over the nominees to be held over. And if we get 11 here, I'd like to take time to get the U.S. Attorney for Southern Florida voted out by voice vote. We have 12 judicial nominees who appear on a markup agenda for the first time, and the nominee to serve as Director of National Drug Control Policy. At the request of the minority, we will hold over these nominees. We will also vote if we have a quorum, as I just said, on the U.S. Attorney for the Southern District of Florida. Before we turn to today's agenda, I'd like to speak briefly on the Supreme Court nomination. I mentioned last week that Judge Kavanaugh's confirmation hearing will begin September 4. Senators will have had by then 57 days between the announcement of Judge Kavanaugh's nomination and the start of the hearing. This is a longer period than we had for Justices Sotomayor, Kagan, and Gorsuch. This longer period of time is a period of time that is just another example of how this is the most transparent confirmation process of all time. In his 12 years on the D.C. Circuit, Judge Kavanaugh issued more than 300 opinions and joined hundreds more. As Senator Schumer and Leahy said during Justice Sotomayor's confirmation hearing, a nominee's judicial record is the best way to evaluate a nominee. Judge Kavanaugh also submitted more than 17,000 pages with his bipartisan Judicial Committee questionnaire, and that happens to be the most robust questionnaire given to a nominee. We've also received nearly 250,000 pages of documents from Judge Kavanaugh's service in the executive branch, and this is already more than any previous Supreme Court nominee, with many more documents yet to come. Most are already publicly available, and we're working to make the vast majority of them publicly available as quickly as possible. We have plenty of time to review all these materials before the hearing. In fact, the majority staff has already reviewed nearly 80% of them. Unfortunately, some have tried to criticize what is the most transparent confirmation process, but I think they're failing, and they're failing because Democratic leaders have made their true goal obvious. Stall the confirmation as long as possible in hopes that the Senate may flip in the midterm elections. I think they've tried to unsuccessfully apply the Biden rule, which bars confirmation during presidential election years, and which they used to say they didn't even exist to midterm elections. When that fell flat, they generated a controversy about documents in a desperate attempt to delay the confirmation. Lest there be any doubt, we're following the precedent established during Justice Kagan's confirmation. Like with Justice Kagan, we're requesting a very significant number of Judge Kavanaugh's documents from his time in the executive branch, but both sides agreed not to ask for internal documents from Justice Kagan's time in the Solicitor General's office because of their sensitivity. Likewise, we're not asking for Judge Kavanaugh's documents from his time as staff secretary. These documents are even more sensitive because they contain advice sent directly to the president and are at the heart of executive privilege. Some have said that we need these documents because Judge Kavanaugh stated in his time as staff secretary that those times were formative for him. Well, Justice Kagan described her time as Solicitor General as indicative of how she would serve as a justice. We still didn't ask for her Solicitor General papers, and we won't ask for Judge Kavanaugh's staff secretary's papers. Additionally, some of my colleagues have forgotten that we had a more compelling need for Justice Kagan's documents because she had no judicial record. She had issued 0 opinions and joined 0 opinions at the time she was nominated. Judge Kavanaugh, by contrast, has issued over 300 opinions and joined hundreds more in the 12 years on the bench. Despite having a less compelling need for them, the Senate is still going to receive hundreds of thousands of more pages of documents from Judge Kavanaugh's time as a government lawyer than we did from Justice Kagan. There have been some criticisms of the way in which the review is being handled. These criticisms are groundless. First of all, the National Archives are not being cut out of the process. President Bush is legally authorized to review his administration's documents and decide which ones to release to the Senate and claim that others are privileged. That's exactly what his team is doing now. Additionally, some have labeled the attorney, Bill Burke, and he's the leading attorney in the review of President Bush's documents, as a partisan lawyer. From what I've found out from other people who know him, he's not. He's a partner in one of the most liberal law firms in the country and has been President Bush's Presidential Records Act representative since President Bush left the White House in 2009. Mr. Burke handled the initial review of Justice Gorsuch's documents, and there were no complaints about his doing that at the time of Justice Gorsuch being considered by this committee. I also don't recall complaints of partisan lawyers reviewing Justice Kagan's and Justice Sotomayor's documents. Bruce Lindsay, who was National Director of President Clinton's 1992 campaign, senior lawyer, and a person that helped fix things for the White House, and a longtime CEO of the Clinton Foundation, reviewed Justice Kagan's documents. Leslie Kiernan, also a prominent in Democratic politics, reviewed Justice Sotomayor's documents before the Senate received them. If these individuals could review nominees' documents before producing them to the Senate, then I think it's perfectly legitimate for Mr. Burke to do as well. And so I don't see the rationale behind the criticism. The following nominees will be held over: Ryan Nelson, Ninth Circuit; Richard Sullivan, Second Circuit; Gary Brown, East District of New York; Stephen Clark, Eastern District, Missouri; Diane Gujarati Rodi, Eastern District, New York; Eric Committee, Eastern District of New York; Rachel Kovner, Eastern District of New York; Louis Lyman, Southern District, New York; John O'Connor, Northern, Eastern, and Western Districts of Oklahoma; John Sinatra, Western District of New York; and Mary Vishkashel, Southern District of New York; Joshua Wolson, Eastern District of Pennsylvania; and James Carroll, Director of National Drug Policy. Let's see, we do not have enough to do that at this time. So what I said, they'll be held over. We'll have to reach that decision later on. We also have a bill to consider, S 2961, Victims of Child Abuse Act reauthorization, is on the agenda for the first time. The bill extends a program last authorized in 2013, which makes federal resources available for more than 850 children's advocacy centers across the country These centers rely on multidisciplinary teams to do forensic interviews of child abuse victims. Senator Blunt introduced this bill. I'm a co-sponsor along with Senators Coons, Cornyn, Durbin, Hirano also. Now it's time for Senator Feinstein and other members to speak.